What if I told you that your debt might not even be legally enforceable? Most people don't realize that banks and debt collectors are making money off of your debt in ways that you never agreed to. In this video, I'm going to break down how debt discharge actually works and what you can do to actually challenge debt legally. So just to give you guys a little standpoint, I have the complete debt guide down below, and I've helped countless people be able to discharge their debt or even challenge their debt legally. All right. Now, today I'm going to show you guys how it's done. Now, before we dive into that, if you're brand new, make sure you like, comment, and subscribe. If you invest in me, I'll invest in you by continuing to drop more bangers. Okay. Also, if you didn't watch my last video, go take a look at my last video. All right. Okay. So I'm ready to dive straight into it. Okay. So I'm going to give you guys the truth of how debt actually works. Just a brief breakdown. Most people think that when they take on a loan or a credit card balance, the bank is actually lending them real money. The reality is the bank isn't lending you any money at all. These are just book entries. They actually create money when you apply for it. Okay? They take your promissory note and exchange it with the Federal Reserve for the actual money. And then on top of that, they're able to multiply that 10 times. You dig me? And all of this is written in the book called Modern Money Mechanics. And it's also written in some of these laws that I'm going to discuss here. Okay. And in my other videos where I talked about bank fraud. Now, the reality is, banks going to create this money out of thin air. And essentially, after they do that, they sell your debt as an asset, which is very interesting. Okay. How can you come after me for money that you created out of thin air that you're eventually going to sell? Okay. So if what this means for you is that if your debt has already been paid by the system, why do they still try to collect from you? We're going to be discussing some of the laws that protect you from paying unenforceable debt. Okay. Now, straight off the bat, man, simplest thing, 15 U.S.C. 1692 G, validation of debt. I already made a video on 15 U.S.C. 1692G, but to highlight that this is the number one way or the starting point of you actually discharging debt. Okay. I have a lot of content on 1099. I talk about the aspect of utilizing negotiable instruments, but the premise of making those things work is actually having them prove that the debt is actually valid. Okay, these are some of the things that you put in place to challenge their jurisdiction. All right. If they say, oh, well, you can't use a coupon or you can't use this, then challenge whether the debt is actually something enforceable. Because if you're telling me I can't perform on this, now I'm going to challenge you on that contract. I'm going to challenge your jurisdiction. I'm going to challenge if you can even come after me for this debt. Dig me? There's multiple ways to be able to go about challenging debt, and 15 U.S.C. 1692G shows you exactly how you can validate debt. This is the simplest form of discharging debt, okay? Because if they cannot validate this debt according to these procedures highlighted in 15 U.S.C. 1692G, then they cannot collect. You feel me? And it goes for all debt collectors, all right? Do you guys gather that? Moving on. Then we dive into UCC 3-305. Now I'm going to break this down a little bit later in this video. UCC 3-305. Okay. But essentially, one of the big things is the right of a holder in due course to enforce an obligation of a party to pay an instrument is subject to the defenses of the obligor stated in the subsection, but is not subject to the defenses of the obligor stated in subsection A2 or claims in recruitment stated in subsection against a person other than the holder. So the whole point of this section here, okay, it also talks about the defense of the obligor, kind of skip through, an extent as a defense to a simple contract, duress, lack of legal capacity, illegality of a transaction which under other law nullifies the obligation of the obligor, okay? If it's fraud, right? Without a person having knowledge, no reasonable opportunity to learn of its character or its essential terms, the discharge of an obligor in insolvency proceedings. And there's a lot to unpack here, and I definitely would highlight anybody to go and take a look at this law themselves. But essentially, if your debt has been sold, the new owner might not have legal right to collect from you, okay? So essentially, you want to demand proof of ownership and proper assignment. You have a right as a person who is obligated to pay a debt to challenge the person who is saying you're obligated to pay the debt. And it says here that if you sign something under duress, or something, or that contract has a lack of legal capacity, or is illegal, it's an illegal transaction, okay? It nullifies the obligation of the obligor, okay? It also says that if there's fraud induced, if it's fraud that induced the obligor to sign the instrument with neither knowledge nor reasonable opportunity to learn of its character or to censor terms, the discharge of an obligation, okay? So it's so funny that a lot of this stuff happens. If you've never been disclosed information of your actual contract in the lending aspect of it, then that is considered fraud. Okay, if they didn't tell you all the terms up front or even make that stuff clear and conspicuous, then it becomes a fraudulent contract. And then we dive into 12 USC 1431, powers and duties of banks. Okay, they have the ability to borrow and give security, therefore to pay interest thereon, issue debentures, so on and so forth. And so the whole point of this subsection pretty much highlights how the banks package and sell your debt as securities, meaning that your debt already got paid. Okay. And essentially you can use this as leverage to dispute debt, to challenge the legal consideration of whether or not they're actually loaning money. Because again, if this says that they only borrow and give securities, then how are they loaning money? Dig me? So I want to go back to 3-305, okay? And I want to just break down essentially what holder in due course means, okay? A holder in due course is someone who legally owns a negotiable instrument like a loan, promissory note, or a check and can enforce payment, okay? To qualify as a holder in due course, the holder must have received the debt in good faith. You dig me? Without knowing about any legal issues or dispute surrounding it. Okay? Why does this matter when it comes to your debt? When a bank sells your debt to a third-party debt collector or another financial institution, the new entity may not be a holder in due course. If they cannot prove that they legally own your debt under UCC 3-305, they may not have a right to collect from you. And I say may because, again, there's so many different factors that comes to play. Okay? Now, here are some defenses you can use under 3-305. Under this rule, there are three main types of defenses that can be used to challenge a debt. Okay? So I want to talk about some of the real defenses when it comes to holder in due course. I don't want to give you guys no BS, no flack. So this goes for a person who is a holder in due course. Okay? So essentially, if there was fraud, I already discussed this. All right? If you was misled into signing a financial agreement without understanding it, the debt may be invalid. That's number one. Number two, if there was some type of forgery, if the original contract was forged, it cannot be enforced. So when you think about it, on an aspect of there's people who have fiduciary obligations and is utilizing it's pretty much signing your contracts for you. Okay? If you did it under duress, okay? So if you was forced to sign something under pressure or the contract was illegal, it is not enforceable. So if you go to a car dealership and they say that you can't get this car unless you sign it in a certain type of way, or you can't get this car unless you sign this agreement, or you get these service fees and this, that, and the third, and you sign it because you are essentially forced, that is not enforceable. As a matter of fact, that is illegal. And then number two, if the debt, and this is the biggest one, if the debt has already been paid, settled, or discharged in a bankruptcy, it cannot be collected, which brings me to House Joint Resolution 192. And someone will say, oh, House Joint Resolution 192 was repealed. Okay, so why do they break down this stuff in the Constitution? Okay, so first of all, on June 5th, 1933, okay, essentially they eliminated the gold standard because the United States was bankrupt. So the country is bankrupt, and they've been bankrupt this entire time. Okay, so essentially it discharged all obligations, because why would a country who owns you Because if the country owns you based on the birth certificate and you acquire debt, did you know that that actually becomes their debt? We can go to 18 USC 8. It says the term obligation or other security of the United States includes all bonds, certificate of indebtedness, national bank currency, Federal Reserve note, Federal Reserve bank notes, coupons, United States notes, Treasury notes, gold certificates, blah, blah, deposit, bills, checks, drafts, or money. The thing is the United States insured your obligations because they own you. When your mom signs over your birth certificate, they own you. So if they own you and you acquire debt, it now is their debt. But it just said that if one is bankrupt, then their debts are discharged. So why do you have to pay a debt if your debt is discharged? Make you think. So in an example, if a lender already sold your debt as a security, they may have received the payment, which means they no longer have a legal right to collect from you. So as soon as something gets charged off, as soon as something gets sold to a collection agency, that debt is already settled. You don't have to pay something that's already charged off, and you don't have to pay something that was sold to a debt collector. When we talk about 1099, 1099-Cs actually discharge your debt, okay? So if you file a 1099 and your debt becomes discharged, you want to challenge the holder in due course, if they're actually a holder in due course, under the premise of UCC 3-305 and say the debt has already been paid, settled, or discharged. You dig me? Now, I want to talk on the aspect of against debt collectors, because that first aspect is if the person is an actual debt owner and is a holder in due course. So this is specifically for Capital Ones, the Bank of America's, thing in that nature. Now, when it goes to a debt collector, okay, they are not a holder in due course. Just because they buy a debt doesn't mean that they own it. You feel me? So, number 2, failure of consideration. If the lender didn't actually provide you with the loan in the way that you agreed to, you may not be liable to the debt. Okay, so they have to prove consideration. Number 2, if there's a breach of contract, if the lender broke the terms of a contract, you can use this as a defense. Okay? And number 3, if there was misrepresentation, if you were misled about the terms of the agreement, you may not be responsible for the debt. Think about it for a second. All right? If they cannot prove that they loaned you money, you are not liable. If they breach a contract, you aren't liable. If they misrepresent or misled you, making you think that you're supposed to pay a debt that's already paid, if they didn't tell you where the money actually came from, then this is a form of misrepresentation. Or even if they change the terms of the loan, this puts you in a position where you may not be responsible for the debt. However, you have to prove this. You have to challenge them and ask them these questions to prove that they cannot answer them. So not only are you filing a 1099, a coupon remittance, things in that nature, you have to challenge them. Dig me? Now, for example, if the bank changed the terms of your loan without your knowledge, a debt collector may be trying to enforce new terms that may not be valid to UCC 3-305. Okay? Another thing is if there is a lack of standing. Okay? Many debt buyers don't have the original contract or proof of the proper assignment from the original lender. That's number 1. Number 2, if they cannot prove that they're a holder in due course, they may not have a standing to take legal action against you unless you contract to it. And number 3, this is why you must request a validation of debt under 15 USC 1692G, because it is so powerful and it forces them to prove they have legal right to collect. Just 15 USC 1692G. It's asking these questions. It's factoring in the commercial laws of the UCC, okay? So I want to bring it back to how you want to essentially do this properly, okay? Number 1, you want to request debt validation. Start there. Send a letter under 15 USC 1692G and demand a full validation. When you say 15 USC 1692G, they're supposed to provide full validation. You dig me? And if they cannot provide a contract with your wet ink signature, the debt is questionable. That's number 1. Number 2, you want to check for violations under the Fair Credit Reporting Act and the Fair Debt Collection Practices Act. Because if they report inaccurate information, you can sue them. You can use this lawsuit to be able to challenge the credit bureau. I mean, not the credit bureaus, but to challenge the debt collector to strategize You feel me? Get them to negotiate with you, because would they rather pay a debt, or would they rather be sued for something? Especially if they violated your rights, because now it doesn't, yeah, I could owe you something, but I'll just get the money from you guys. And being sued is much worse. Okay? Then we dive into how to be able to use the aspect of the UCC. You want to ask for proof that the collector is a holder in due course. Okay? You want to challenge the assignment of the debt. Request proof of assignments showing the chain of custody from the original lender to the current collector. And if they cannot produce any original wet ink signature or wet ink contract, they aren't a valid holder in due course. You also want to identify those violations of the UCC 3-305. I'll talk about that in a separate video, but look for reasons why the new debt collector may not be the holder in due course: improper documentation, missing proof of ownership, or previous discharge of a case. You want to make sure you use real defenses, okay? The original debt was discharged, fraudulently created, or already paid off through securitirization. The new debt collector may not have the right to collect, so you don't want to just challenge them on just open statements, screaming these laws at them. You need to actually challenge them on some valid and real defenses, okay? So just some key takeaways. The UCC protects you from paying a debt to a debt collector who isn't legally entitled to it. Number 3, many debt buyers don't have holder in due course status, which means that they cannot legally enforce the debt. And number 3, by debt validation, contract disputes, and real defenses under UCC 3-305, you can challenge unfair collection practices. Okay? Now, here's a couple of myths. Okay? Myth 1, debt discharge means you stop paying. Okay? That's not true. The truth is that there's legal ways to challenge a debt and get it removed. That's the truth. You must challenge it. Discharge doesn't mean that it's wiped away. It means that debt discharge is transferring the obligation from one party to the next. So it's not that somebody's not getting paid. Okay? And when it works, if the debt is invalid, improperly assigned, or unverified, you have a right to dispute it. So you want to challenge the fact on if something is invalid, improperly assigned, unverified. And if you aren't doing those 3 things, you may not even have a chance. But if you use these laws that I discussed today, then you're putting yourself in a position where you have a chance to challenge those things. You can do a coupon. You can do all these forms and IRS forms. But this is only put in place to make something unverifiable, make something already be discharged, and you have proof of it. You dig me? You still have to understand the legal process. You still got to understand the administrative process. Okay? So, if I helped you understand debt discharge, hit that like button, subscribe, because I've got more game on credit, funding, and financial freedom. If you wanted to learn how to do this, you wanted a full breakdown of this, I have to complete that guide down below. Okay? It's only $47, and you essentially get all this knowledge that I'm talking to you guys. You get it all in one place, so you don't have to keep waiting on videos. Okay? A more deeper dive in some of these things that I'm talking about. Okay? And also at the same time, I have more links down below if you want more one-on-one help. Take advantage of these things. Okay? Thank you guys for watching this video. Again, take action, challenge the debt, challenge these people, hold them accountable, because if you do that, the system may change. Thanks again. I love you, and I'll see you next time. Ha!